Showing on this episode of Law Weekly, a conversation about conflicting court judgments, public perception of the judiciary, and the need for urgent reforms in that sector of government. My guest, Senior Advocate of Nigeria, Professor Koinsola Ajayi, believes that if Nigeria has a judiciary with integrity, one that lives up to expectations, all the country's challenges can be surmounted. We'll get to that conversation in a bit, but also showing on the program, the Nigerian Institute of Chartered Arbitrators makes the case for promotion and patronage of Nigerian arbitrators, restates commitment to fostering transformative trends in arbitration and ADR practice across Nigeria, and nurturing the next generation of arbitrators. Plus our recap of the top trending stories in the news. Hello and welcome to the program. I'm Shola Shoyeli. The Nigerian judiciary has come under severe criticism in recent times, owing largely to a loss of confidence in court decisions and conflicting rulings. Only last week, the National Judicial Council (NJC) sanctioned 5 judicial officers for various acts of misconduct. 2 justices were suspended from performing judicial functions for a period of 1 year without pay and placed on a watch list for 2 years thereafter. Another 22 justices had petitions against them dismissed for lack of merit. And that is the starting point of my conversation with Senior Advocate of Nigeria, Professor Koinsola Ajayi. How bad really is the situation with the Nigerian judiciary?
I think the honest truth is this, that we have to take a step back to understand the nature of the problem and see whether this is true or not. And stepping back is understanding the role of the judiciary in society. So you go back to our constitution, we have 3 arms of government: executive, legislature, judiciary. And kind of, the judiciary is the most important. They have the last say. They say, this is the way. They say, this is what the Constitution means. They say, this is what the legislature means. They say, EFCC can or cannot do this. President, you can or cannot do this. So they're at the top of our constitutional framework. And therefore, everything, devolves on the judges. And it is the case that lately, as published publicly, that the Nigerian judiciary was accused as being the most corrupt element of the Nigerian society. Now, I'm not a statistician, but this is what is in the public domain, and this is what is in the public mind. And so it begins to answer the question, is there a problem? There is. There is a fundamental problem, such that it is believed by some, including me, that the Nigerian problem of today is not what most of us say it is, which is it's corruption, corruption, corruption. I think that if we have a judiciary that lives up to its expectation, all our problems will be solved.
All.
More or less like a magic wand, because people are corrupt simply because there's no consequence. And the consequence only sounds under our constitution with what the courts do. It's been said, the judiciary is the one that is beginning to burn the house.
Because you said if the judiciary gets its acts together, all our problems will.
I fundamentally believe so. And so what are our problems today? They're political, they're economic, they're social. And if you look at all those problems, you would see that they're all intricately tied to the judiciary. As it is, more or less, the courts now decide who becomes elected. Nearly every election ends up to be decided in the courts. So the problem is this, that because the judiciary is not living up to its expectation, in terms of when I quarrel with you, Shola, we go to the court to help us to determine whether this is your chair or my chair, whether this is the boundary between us. Now, if you go to the court and the court takes money from you and decides, it's a problem. If the court doesn't take money from you, but the judge is lazy and decides it badly, it's a problem. If the judge doesn't decide the case in good time, we begin to quarrel. And so you see how the judiciary gets into what we do as members of society. I think there's a lot that is on the head of the judiciary, and I think they all need to begin to know the fundamental role that we placed on them. And at the top of it, they say that they are like God, that they cannot make mistakes, that they are infallible. Though they are humans and can make mistakes, but then what they say is final. So if you know that what you say is final, it means that you must be responsible in the things you do and bear in mind the extreme nature of the power that you exercise over millions and millions of people. We're talking of 200 million people and our lives being in the hands of maybe 2,000-3,000, magistrates, customary court judges, Sharia court judges, high court, federal, and all that. So it's a lot of power in their hands.
Do you agree with those who say that for there to be any meaningful reforms, it must start with the National Judicial Council? That's the body that is saddled with the discipline of judges. I say this because last week we saw that the NJC moved against 5 judges. 2 of them had falsified their age. And the NJC merely recommended their dismissal and said that they should pay back the monies that they had collected. There are those who thought that the NJC should have gone a step further to recommend them for prosecution. We don't see that. So the role that the NJC is playing, do you think that reform for the kind of judiciary that we all want to see should start with the leadership of the judiciary?
I see the point. It's well, first of all, good thing that it took action. Sadly, it took some time to take the action, which is where I think the problem is. And yes, there must be reform in the way NJC works. Now, NJC is constitutional, so there may be a little bit more that needs to be done to tinker with the body, but we don't need to wait for amendment of the Constitution for NJC to begin to do things properly. Now, what are the things that it can do? The first thing is that I think the process has been too lawyerly. It's been too technical and, I dare say, too protective of judges. It's more or less like home justice. And so what can the NJC do? It can, first of all, fast forward its process.
Yes.
NJC is in Nigeria, for instance, and sees there's Justice Lehman, who has just been elevated to the Court of Appeal, surprisingly, from the Federal High Court, ruled, they say, from United States of America, that an emir should or should not be appointed, Federal High Court. Well, jurisdiction or jurisdiction, it's a question of, where you sign. But the point is, should he have taken a file at 5 a.m. Nigerian time or 2 a.m. Nigerian time in California? He rules, and then you have another judge that rules to the public. Should NJC wait for a petition to move against those judges and just deal with it? Because that is like a bleeding that is going to kill you. We know registry closed by 3-4 p.m. So how can you take a case not in Nigeria at 2 a.m. Nigerian time? How? What can be the justification? There just cannot be. And so that for me doesn't need anything else because it is existential problem that we face. And so if the judiciary is a problem for the people, then we have to deal with it because you know what, Shola? If we do not, it will happen. And we don't want that to happen. We don't want people to take laws into their hands because it's happening in other parts of the world. And so I think we owe it as a duty and to get to this. And it's not just the NJC. We lawyers, we feed the judges. What do we do? What applications do we break? What should you do to that lawyer, whether senior advocate or not, that knows that a judge has given an order in court A and then goes to court B to seek to get another order? That lawyer should also be dealt with peremptorily.
And we don't have to wait for a petition.
We don't have to wait for a petition because it's there for the whole world to see. And again, the litigant, me, the candidate that knows that my opponent got an order against me, why would I instruct a lawyer to go elsewhere? So we need to deal with this as it is. So it's the judge, the lawyer, and the litigant. And until we begin to deal with the three, and seriously, like you strike off lawyers from the role that really abuse the system and bring the whole system to dispute and cause injustice to others, we're going to continue to have this problem.
So in terms of agenda setting for the CJN and referencing all that you've said about these issues of discipline of judges and all of that, what are some of the things that you think that the CJN can quickly do to regain public trust and confidence in the judiciary and dispense justice the way that we all want to see it dispensed?
Okay,
Fairly.
so I like to think that I don't flatter anybody. And so with all sense of seriousness, I say that Justice Kekereekun coming in has put a break in this sliding confidence, because as a person, she comes with a high degree of respect and a perception that the public has of a woman of integrity, which is a big plus for the office. She's always comported herself as a proper judge. And so that's one good thing that she has. And I think she needs to keep it up, and she needs to make sure that she does not climb that ladder that other heads of courts have, where they begin to kowtow to the executive and legislature. So that's the first thing.
Even though some have faulted her for attending that dinner where the governor of Lagos hosted her for her elevation, some people felt she should have declined.
So, well, maybe, for some people would say maybe not. I don't personally see anything wrong with it. But I agree. And as I said, she shouldn't climb that ladder where, other heads of courts have, which is to climb the political ladder and begin to bring down the image and the high office of judge. So that's one thing. And I think, so she just needs to hold on to where she was, because it's very tempting to depart from where she was and begin to enjoy, the exposure and, all that comes
with that office.
With the office and mixing with politicians and so on and so forth. The second thing is that I think, and I believe she's signaled it, she needs to get serious, because we've been unserious about using technology in the courts. And I'm not just talking of, I'm talking of AI in helping the judges in analyzing the cases, because it begins to take away some of the hanky-panky that the judges get to. The judge says, I don't believe you, doctors, your evidence, and so on and so forth. But if you use AI, you cannot do that. The thing is, it's a machine and just reads it and deals with it and makes the job simple. So what that does is take away hanky-panky, makes the process quicker, is more scientific. So that's one thing that I think can be done very quickly, no need for change of law. Also, is discipline. I think as head of NJC, she should look at a system where NJC doesn't have to sit at every point to determine how to deal with discipline of judges. I'm not a member of NJC. I do not know how they operate. I hear about how they operate. But what I know is that it just takes forever for them to deliberate.
Sure. And
so it just needs to be quicker. She needs to bring out a more efficient system. Now, I would say, for instance, look, a judge, as I said, is supposed to be above board. Now, no judge should find himself being subject of a petition. This was more or less not heard of. But now, it's common to find petition against judges. So I think she should do two things. Number one, anybody that writes a petition against a judge will now be held to it. If you write a petition against a judge and it's found to be frivolous as a lawyer, they should discipline you. That would mean that I would not write a petition
if you're not
or
sure.
support my client to write a petition if I'm not 100% sure.
Yeah.
Second thing is, if the litigant is one that writes a petition, again, there are ways in which you deal with the litigant. You cannot make false accusations and, cook up stories or bring administration of justice to dispute so they can move against you for that also. And then the third, most important, is the judge. CJN should have a system where a petition comes, it should be read that day and determine that day whether this is good or bad. Take it as a patient that has come to the hospital. You treat the patient, you look at the patient that day. You may decide to admit, I will treat your treatment later, but I will still see you. So when a petition comes, read it that day, determine whether there's something. If there's something, tell the judge there's something, step aside. And we deal with it quickly. Now,
because the other side is that some litigants, when they've drawn a judge that they feel is not favorable to them, that they start to write serial petitions.
Write petition, but then no. So there was a lawyer who I tried and was convicted. He was making allegations against, I believe, Justice Okuno. Just making spurious allegations and petitions. And so the criminal law is there that when you make spurious allegations against a judge, you can be tried. He was in prison for 4 months. A senior lawyer in this Lagos. And so when you do that, people will stop. So, I think the CJ should look at that system where, these petitions are cleared maximum within a month. And once it's on, judge recused or judge suspended. And then, you're either going to be dismissed, suspended, or do what they need to do. Or you get back to your work.
Welcome back. Ahead of its annual conference scheduled for November 28 and 29 in Lagos, the Nigerian Institute of Chartered Arbitrators held a press conference in Lagos to restate its commitment to the transformative trends in arbitration and alternative dispute resolution (ADR) in Africa. The Registrar and Chief Executive Officer of the Institute, Mrs. Shola Oshodi-John, alongside some members of the Conference Planning Committee, spoke on the need to prioritize arbitration as a lucrative tool for economic growth and enact policies that include and patronize Nigerian experts, especially in cases of public interest.
We're looking at some germane topics for this year's conference, and one of the areas we're looking at is the issue of AI. We all know what is going on right now. There's a lot of new developments in the artificial intelligence space, and we find ourselves asking the question, what is going to be the future of arbitration with the new developments with AI? Are things going to remain the same? Will AI be able to serve as an arbitrator, devoid of emotions and all that goes into it? And we're also talking about the African Free Trade Area Agreement, which Nigeria is also a signatory to, and a lot of African countries are signed on to. And we know that the Dispute Resolution Protocol for AFTA deals with state parties, but the question that we always ask ourselves, what is going to happen to disputes by private actors? How will they resolve their dispute, given bureaucracy and a turnaround time when we have to deal with ourselves within a state, not to talk of interstate? So we're going to be looking at that. One of the things we are looking at is the need for us to come together. There has to be a convergence of common law and civil law jurisdictions in Africa. How do we close the gaps? We are so close, but yet so far away when it has to do with our laws and when it has to do with dispute resolution and also with trade. So these are some of the things we are going to be looking at. And then one other topic that is very, very close to our hearts has to do with the place of transparency and accountability in arbitration. Is it possible for us to begin to ensure that there's due process, in all that we do when it has to do with the commencement of arbitral hearing to the delivery of the award and the enforcement? How do we ensure that the standards are kept and that arbitrators are held accountable to the high standards? Because you all know that arbitration is a very noble profession, and it's made up of professionals across different fields and different fields. And so we want to be sure that the arbitrators that are coming out from this side of the wall are among the top. One of the other sections we're going to be talking about is the business human rights agenda for business organizations in Africa. Organizations, multinationals that do business in Africa needs to begin to be held accountable.
There's nothing about arbitration or the history of the Institute that she has not told us. She only pointed at some of the things that we'll be discussing, and one of the most interesting things is what the AI may be doing in arbitration. But that's not only in arbitration. This occurs in every other profession too. The other day I was reading something like in the US, a lot of lawyers are afraid of losing their jobs because AI might be able to do better litigation and faster, and so are doctors. So these are the things we are going to look at. Is AI going to be able to replace arbitration? Will it be complementary? Will it be taking over? These are the things we want you to look at for us. We want the public to understand what arbitration and ADR is. ADR being alternative dispute resolution. These mechanisms are the things we use if we don't want to go to court.
And just before we go, a quick look at some of the major court stories we tracked this week.
We begin with the report that the Supreme Court has struck out a suit by the 36 states government, seeking among others to compel the federal government to account for its earnings from the sale of liquefied natural gas liquids and related products since 1999. In a unanimous judgment, a 7-member panel of the court held that the court lacked the original jurisdiction to hear and determine the suit, which has the Attorney General of the Federation as sole defendant. In the lead judgment, Justice Mohammed Garba upheld the preliminary objection raised against the suit by the AGF and held that the subject of the case had been dealt with by the Supreme Court in its earlier decision in the case of the Attorney General of Bauchi State against the AGF. Justice Garba agreed with the defendants that the suit amounted to an attempt to relitigate issues already decided by the Supreme Court, which relates to the revenues accruable to the governments of the Federation, which are payable into the Federation account. The judge proceeded to strike out the suit for want of jurisdiction to hear the case as constituted. Another panel of the Supreme Court has nullified the National Lottery Act 2005 enacted by the National Assembly. In a unanimous judgment, a 7-member panel of the Apex Court, read by Justice Mohammed Idris, held that the National Assembly lacked the powers to legislate on issues relating to lottery and games of chance. The court held that such powers only reside with the state houses of assembly, which possesses exclusive jurisdiction over lottery and games of chance. Justice Idris ordered that the National Lottery Act 2005 should no longer be enforced in all states except the Federal Capital Territory, in respect of which the National Assembly is empowered to make laws. The judgment was on the suit filed in 2008 by Lagos and some other states. Away from the Supreme Court, the Court of Appeal Abuja has reserved judgment in an appeal by the Governor of Rivers State, Simina Alai Fubara, who is asking the courts to set aside the judgment that barred the Central Bank of Nigeria, CBN, from releasing monthly allocations to the state. The governor, through his lawyers, led by Senior Advocate of Nigeria, Mr. Yusuf Ali, asked the 3-member panel of the Appellate Court, led by Justice Hama Barka, to vacate the order of the High Court. The governor also urged the Appellate Court to allow his appeal and nullify the orders made by Justice Joyce Abdul Malik of the Federal High Court in the judgment she delivered on October 30. Through their respective counsels, the appellants asked the courts to allow their appeal. The Martin Amewele-led group of the Rivers State House of Assembly, through their team of lawyers led by Senior Advocate of Nigeria, Mr. Joseph Daudu, asked the courts to dismiss the appeals and affirm the High Court's judgment. After all the sides adopted their briefs of argument, the panel reserved its judgment till a date that would be communicated to the parties. At the Federal High Court, also in Abuja, Justice Ekerete Akpan has ordered that the 109 foreigners linked to high-level cybercrimes, hacking and activities threatening national security be remanded in Kuje and Suleja correctional facilities to the next adjourned date. Justice Akpan made the order following the request by the counsel for the defendants, who said that the police facility where they are kept was not conducive for the number of suspects. The arraignment of suspects was also stalled owing to issues of misrepresentation of names of the suspects on the charge sheet and also issues of counsel representation. Counsel to some of the defendants, Ogu Onoja, told the court that there was need to have interpreters who will be present in court during proceedings for the sake of those who do not understand English. After listening to the submission of the lawyers in the suit, the trial judge adjourned the case to November 29 for further arraignment. And we round off with a report that the former Minister of Petroleum, Desiani Alison Madueke, has sought to amend her suit before Justice Iyank Eko of the Federal High Court, Abuja, challenging the order obtained by the EFCC for final forfeiture of her seized assets. At the resumed hearing of the court suit on Thursday, November 21st, no counsel appeared for the EFCC. Justice Eko asked the counsel if he had received processes from the anti-graft agency, and he responded in the affirmative. The lawyer, however, informed the court that they had filed a motion to amend the processes and that the commission had been duly served. Justice Eko subsequently adjourned the matter until February 17, 2025 for hearing the motion to amend their originating process. Mrs. Alison Madueke is alleging, among things, that she was not given a fair hearing in all the proceedings leading to the orders obtained by the EFCC for final forfeiture of her assets.
And that's the program for today. Do remember to check out the Channels TV website for a replay of this episode of the program, as well as past episodes. Please also send in any feedback via our social media handles. I'm Shola Sheele. Thank you for watching, and see you next week.